there are about dozen slides with almost 2 dozens of case laws. This is not going to be a small session, but at the end of the session, if you ask me, is this covers everything? My answer will be no. There is one topic which you can keep on discussing under Evidence Act is clause 1 of section 32, which is all about dying declaration. Now, this is one topic you can conduct as a workshop in your college which can go of 8 hours, and at the end of 8 hours you still think that there are many more things to be discussed. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act we were discussing chapter 2, which is all about relevancy of facts, and there are two sections which are standing as exception for hearsay, that is section 32 and section 33. We have already discussed section 32, and here we are going to focus on one of the very important clause from section 32, that is clause 1, which is all on dying declaration. I have a lengthy video, not wasting any of your time. Let's get into the first slide. Clause 1 of section 32 discusses about those statements which are related to cause of death. First, let us go through the section and then I will explain the same with the help of easy and beautiful chart. It says, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death. So there are two aspects we need to observe, and in cases in which the cause of that person's death comes into question, such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. Now that's what sections say. How to read it easily? Let's try understand the same with the help of my chart. First thing first, there is a statement made by a person. Now what is this statement? This statement is an answer to a question which is related to his death. Now a person is making a statement, and that statement is an answer to the question which is related to his death. When it comes to his death, we can see two different circumstances. One, he can directly say the cause of his death, that Mr. A has stabbed me and that is why I am dying. Now he is telling the cause of death. Or he can also explain the circumstances of the transaction which resulted in his death. He might say to Mr. X that A has called me to market and he was very angry when he called me to market and he might cause me some danger. Now he has already told the circumstances to Mr. X and then moved to market, and if there is something happens, so he has already given the circumstances to Mr. X. That is also a statement which is related to death if something causes death of that particular person who has made the statement. Now it is not necessary to expect death while making such statement. Now somebody has stabbed Mr. X. Now X is making a statement that Mr. A, B and C tried to kill me. Now he may be expecting death, or he may be thinking that yes, these people will take me to hospital and I will get treated. Now it is not necessary that he has to expect death. It is not very necessary. And what is the nature of proceedings? It may be a criminal case or maybe a civil case. Wherever when there is a question of a person related to his death, if that is arised and if there is a statement by such person who has gone through such risk, then that statement will become relevant under clause 1 of section 32. That's all we need to understand as far as section 32 clause 1 is concerned. But we cannot complete there. I have lot of other explanations which we need to understand. Only then we will understand this completely. So let's get into business. You might be having a question that why do we need so much importance for a dying declaration? To understand that, we need to go through these 5-6 points. First thing first, let us try understand what is the guiding principle for dying declaration. There is a maxim saying that nemo morituris prosecutor mentiri, which means a man will not meet his maker with a lie in his mouth. After death, we all believe that we will go to the land of God or heaven or whatsoever that you believe. There we are going. While going there, we don't want to go with a lie in our mouth. That is what we believe. While that is the one of the concept, there is one more thinking way. Now, when in a case there is only one eyewitness and he is the victim and he is going to die. In such case, if we are not believing him, we don't have any other evidence, we don't have any other eyewitness. In such case, if we don't believe him, that might make the defeat of justice, or it will not help us to reach to justice. That is why the dying declaration is given a lot of importance. And it is also believed that the person who is dying is not scared of anyone. That is why he will definitely say truth. And while dying, somebody's conscience level will be very high because he will definitely think that now after few seconds or minutes I am going to meet God. So I should not lie. That conscience level will be very high level. So that is also one of the reason. And at the time of dying, we will not have lot of selfishness or something to make profit at that very point of time, because that is our last few minutes. So nobody would like to trap someone at that particular point of time. That is also a belief, and the dying person's statement, because of all these reasons, presumed to be true. That is why the dying declaration is given a lot of importance, and these are the few guiding principles which are being repeatedly told in all of the answers when it is asked that why dying declaration is given high importance. There is one illustration given for the cause of death as well as circumstances for death, but let's not invest too much time on that because we are going to discuss a lot of case laws. Let's focus on those case laws which are answering many of question, and by the end we will have all clarity. So let's get into different questions. When are the dying declarations made? Now you might be thinking that dying declarations are made just before dying. And if you are thinking so, it is wrong. It can be in two ways. One, yes, somebody is explaining the cause of his death, which may be just before his or her death. On the other hand, there can be certain circumstances which are being explained by the victim before he or she getting into such circumstances. Now the first one is very easy. A is almost dying and B comes and asks A what happened. Now A says that X came and stabbed me 2-3 times, and because of which I am dying now. That is cause of A's death. Now that is a dying declaration which is very easy to understand. But the second one, circumstances of death. To understand this, we have to refer the landmark case law, that is Pakala Narayana Swamy versus Emperor. What is this case law? This case law is very easy and interesting, and remember, this is one of the most important case law when it comes to clause 1 of section 32, and without mentioning this case law, your answer will not become complete. That very important is this case law. And this is a very easy case law. The facts are like, there was a lady, I will call her as X. Now she takes rupees 3000 as loan from one Mr. A. I will name that person as A, who is the victim here. Now while giving loan, A says that the loan will be charged with 18% of interest. And X, the lady, has agreed. And after few days, she sends him a letter that he should come to her home and collect the money. Now for this 3000 rupees money, whatever he had given, there were sufficient documents available, and on 20th March 1937, that was a Saturday, he receives the letter from Miss X asking him to come and collect the loan amount. What does A do? He informs his wife that I am going to the home of Mrs. X to collect the loan amount, and he leaves home on 21st March 1937, that is on Sunday, and the time he left was the time when he gets a train to the place where X resides. So all the circumstances were right. Now he gone and there was no news of him. But on the other hand, on 23rd March 1937, that is after 2 days of he leaving, on Tuesday, police found one of the trunk in one of the railway platform, and inside that trunk there was a dead body which was made into 7 pieces. Now after postmortem of that body, it was understood that it was a murder. Now this lady to whom he has informed and gone to collect the money, the wife of that person, A's person, comes and recognizes that it was her husband. Now she tells to the court that my husband has gone to Mrs. X's home based on the letter that she has sent, and they have murdered him. Now this is the case law. What is the dying declaration here? Husband, that is Mr. A, saying to his wife that I am going to Mrs. X's home was the dying declaration, because he has given a circumstances of his visit to X's home. Now finally, Privy Council punished the husband of Mrs. X for murdering Mr. A. It is not just because of his statement to his wife, it is also because there was sufficient evidence available for him purchasing the trunk in which they have put the dead body pieces. Now that's about Pakala Narayana Swamy versus Emperor case. A person gave loan to another lady. She wrote a letter to him to come and collect the loan amount. He goes there. They murder him and put in a trunk, and then the deceased wife recognizes that it was her husband's body, and she also tells that he has gone to X's home to collect the money back, and there was letter wrote by X's which was the first evidence. He has went to her home on the specific day which was the second evidence, and then there was a trunk purchased in which the body of the deceased person found, that is the third evidence. However, the dying declaration here made a very important role which became biggest evidence. That's all about Pakala Narayana Swamy case. I repeated it 2 times because you need to know this story. The next case law that you can refer is for the circumstances, that is Ranjit Singh versus State, where a husband was murdered by his wife and her boyfriend. Now there was frequent fight between husband and wife, and there were certain letter transactions between husband and wife mentioning the boyfriend name, etc. So that was the evidence, and few days before the murder of husband, the boyfriend came to their place of residing, like the same village he shifted. That means this is sufficient evidence that they together killed him. That is also circumstantial evidence. Here he has not told to anyone, but he has maintained a diary where he mentioned that his wife's boyfriend has shifted to their village, and on the other hand, there were sufficient letters exchanged between husband and wife related to his issues. So these are also giving circumstantial evidences relating to dying declaration. Now that's how you need to understand when those dying declarations made. Don't think that they were made just before dying. I hope I have spent more than required time in this slide, and you should be clear by now. With that, I am moving to next slide. The next question is, how are the dying declarations made? Now you need to remember that dying declarations can be made via oral communication or via written communications or via gestures. Now oral communication, of course, by himself. Written communication, he can brief to someone and sign the document, that is also okay. And gestures, of course, when he or she cannot speak, they can tell via gestures also. Now for this, the very important case law is Muralidhar Gidda versus the state of Karnataka, where a statement was made by ex parte 22 who died at later stage, and the statement was recorded by PW25U who is a doctor. Now what is this PW25U? That is plaintiff witness 25U. If the doctor is witnessing the defendant, then it will be DW25U. These are the terms you need to know, because while reading a judgment, you should understand all these concepts. Now, doctor recorded that the person was speaking naturally and truthfully, and he had all conscious level, and he has made a statement which can be believed. Now, if doctor says that, that will be considered. So that's an example for oral statement where the deceased person made the statement with a doctor via oral module. On the other hand, in the case law of Alisandri versus R, it was held that if the victim cannot speak, then gestures can also considered as dying declaration, and the same was repeated with a different word, that is conduct of victim will also be considered as dying declaration, which was held in the case law of Emperor versus Abdullah. Overall, in a nutshell, what you need to remember is the dying declarations can be made via oral, written and gestures. That's all for this particular slide. The next question is, to whom dying declarations are made? There is no mention in the law that dying declarations should be made to so and so. It can be made to anyone. It can be made to a magistrate or to a police or to a doctor or to anyone. If it is made to magistrate, then the weightage of evidence will be very high, and if it is made to anyone, then the weightage of evidence will become less. That is what we need to remember. Otherwise, it can be made to anyone, whoever was available. That is what we need to remember. The competency changes from person to person because the technicality among the people I have mentioned here are different. A magistrate has complete knowledge of law. On the other hand, a doctor can analyze complete status of body and mind and take the dying declaration. Now these are the different other aspects are coming in, but anybody can record dying declaration. I have 3 case laws here, and all of them are very important. Especially the first one, that is Kushal Rao versus the state of Bombay, is very landmark judgment because their Supreme Court laid the guidelines for dying declaration. Here it was held that if a dying declaration is recorded by a competent magistrate, and if he has recorded it in the form of question and answer, in that case such dying declaration which is recorded by competent magistrate will have highest weightage as an evidence. However, while recording so, the magistrate need to consider the circumstances. Like for example, if the crime happened during night time, whether the victim has seen the person who has committed crime very clearly, because there can be bad light where there is opportunity of misunderstanding someone with somebody else. All those needs to be clarified. If all those things are taken care, in that case this will be considered as one of the highest weighted evidence. That is what held here. So you might be thinking that whatever is being recorded by magistrate as dying declaration is highest of highest evidence value. But it is not in all circumstances, which was held in state of UP versus Shishupal Singh. What happened here? The recording of dying declaration in this case law also was made by a competent magistrate. But the dying declaration was neither signed by the deceased nor it had the details of date and time of such recording. There were too many missing things, and magistrate couldn't answer that why the sign was missing or the date and time was missing. So under these circumstances, it became quite suspicious, and the court held that the same cannot be considered, or the conviction of the accused cannot be made just on the basis of such dying declaration. The last case law, that is Ram Singh versus Delhi administration. Here a dying declaration was made to police officer. Now it was held in this case law that a clear and corroborated dying declaration cannot be rejected just only because it was recorded by a police officer. That's what held here. That way, a dying declaration can be made to a magistrate, police, doctor, or anyone. Why am I repeating most of the time doctor? Because a dying person is mostly in hospital and doctor has a lot of opportunity to take a statement. That is why doctor is specifically put here. The next question is admissibility of dying declaration. Now, to what extent, or what are the important essentials, or what are the evidential value of the dying declaration? All of that can be discussed here. The most important case law that we need to understand when it comes to admissibility is Sant Gopal versus State of UP. Here it was held that if the dying declaration covers the person who is causing with death, that is of course admissible. Along with that, if the person who is making dying declaration also covers that who are the other persons participating in such causing of death, in that case those facts will also become relevant. Saying so, this particular case law expanded the scope of clause 1 of section 32. That is why this is a very important case law. Now I am giving you 10 important essentials for admissibility of dying declaration. They are: the declarant should have been in actual danger of death at the time when he made the statement. That is very important. He should be in the danger of death. That is why we are calling it as dying declaration. The second one, he should have had full apprehension of his danger or have told someone on circumstances. Either he is passing through such apprehension or he is briefing the circumstances, as we have discussed in Pakala Narayana Swami case law. There we have understood circumstances. The third one, death should have ensued. So he is anticipating death. That is the third aspect. Fourth one, the statement can be in written, oral or gesture form. The fifth one, the cause of the person's death must be in question. That is very, very important because the clause 1 of section 32 itself discusses about cause of the person's death. Only if such things are there, then only we are getting into this section. Otherwise, no, we are not getting into this section. So that is very important. The question should be on the cause of the person's death. The sixth one is the person making statement must be in fit condition to make the statement. When I am saying fit, it doesn't mean physical fitness. He need not to be physically fit, but being mentally fit is very, very important. The seventh one is the statement must be competent. That statement could be able to understand. That is very important. And the declaration must be competent. That is also very important aspect. The ninth point is recorded without tampering. There should not be any attempt to tamper any of the dying declarations gave. That is very important. And finally, if the person who is making dying declaration, if he had made in 2 or more circumstances, or if he has made to 2 or more people such declaration, in that case all of them need to be consistent. If there is any gap, then the same loses importance, which is one another important aspect you need to remember. Now finally, you need to remember that the evidential value of dying declaration depends on who has recorded it. There is weightage for each of them. Then what is the mental status of the victim? That is also very important. The physical status of victim is also important, and to whom the statement is made, that is also important, and the time gap to the incident versus the dying declaration is also very important. If somebody at the moment of dying, somebody was shot and someone comes to that place, immediately he says that X has shot me. Now there was no time frame to think. Now if he is saying so, that is very short time and that has lot of evidential value, because no time for tampering any of the things. So that is very important. The time gap is very important. Language used for recording, the language should be as much as possible in the language of the victim. That is very, very important. And here it can be recorded by any language. It has no restrictions. There is one case law I forgot to mention here. Then the form in which declaration gathered, like it was said in one of the case law which I have already discussed, that if it is taken in question and answer module, that has very good value. However, it can be taken in the form of narration also. But these are the important factors which are giving additional value to an dying declaration. That's what we need to understand. We are discussing everything about dying declaration, and what if the person not dead? Now in English law, dying is very, very important when it comes to dying declaration, but in Indian law, dying is not absolute necessity. If somebody after making dying declaration, if survives, the statement made by them will be utilized for either corroborating or contracting his statement in the court. And there are few important sections comes into picture if the person who has made dying declaration has not died. Now what are they? The first one, section 21 of Evidence Act, which discusses about proof of admission against person making them and by or on their behalf. Here, if the person, if he would have died, the same would have considered, and the state of mind and body of such persons would be considered. That's why the person, if he is not dead also, his state of mind or body will be considered under section 21. And then section 137 of Evidence Act will come into picture to corroborate the evidences, and section 145 of Evidence Act comes into picture where there is opportunity for cross examinations of the statement which are made by the person who was about to die or recorded as dying declaration, and section 155 of Evidence Act, which gives an opportunity to contradict the statement of the person who has made the statement. And section 159 of Evidence Act can be bring in to refresh the memory of the person who has made the dying declaration. And finally, section 164 of CRPC can also be bring in where we are recording the confessions and statements. Here, of course, it is not confession, it will be a statement which will be recorded under section 164 of CRPC. These are the other provisions which will come into picture if the person who has made dying declaration is not dead. Last part of the presentation, I am discussing two important case laws where Supreme Court laid guidelines on dying declaration. The first case law is Kushal Rao versus the state of Bombay, where 6 points were held. The first one is the dying declaration can alone sufficient to convict someone. The second one, while taking dying declaration, the court needs to consider the circumstances. Third and fourth are almost similar, saying that dying declaration is equal to any of the other evidence. The evidential value of the dying declaration is not less comparing to any of the other evidences. The fifth one is if a dying declaration is taken by a magistrate in question and answer module, that has highest value comparing to any other dying declaration. And finally, while taking dying declaration, court should see the circumstances in which the dying declaration was made, like whether the victim has understood the circumstances clearly, that needs to be checked. The capacity of remembering by the victim also needs to be checked. The consistency of the victim on dying declaration, if he has made in two or more opportunities or to two or more people, that also need to be considered. And then whether he was giving the statement throughout in the same way, that also needs to be seen, and how early such statement was made, that also need to be checked. And finally, were there any chance of tutoring such dying declaration, that also needs to be checked. All of these were discussed in Kushal Rao versus the state of Bombay case. The second case law where Supreme Court laid the guidelines is Srimati Paniben versus State of Gujarat. This was again referred in the case of Kalapati versus State of Maharashtra. The Srimati Paniben versus State of Gujarat, the judge there was Mohan S.J. Now, why I am telling this fact? This judgment has laid down as many as 10 guidelines, and if anyone wants to become judge, please read through this judgment because there were 10 guidelines and for each guidelines again reference of case law. This is very beautifully set guidelines. Now tomorrow if you want to give landmark judgment, these are the samples you need to refer. There are 10 points or 10 guidelines. Let us try understand, or I will quickly read through all of them one by one. The first principle is if there is only a dying declaration available as an evidence and nothing else is available, in that case, is it sufficient for convicting an accused based on such dying declaration? It was via these guidelines held that yes, the person can be convicted via dying declaration. There is no hard rule that there are other evidences required. It was discussed in the case law of Manu Raja versus State of MP also. Second principle is the continuation of first principle. If the dying declaration is true and voluntary, in that case, it is sufficient to corroborate the conviction, and the same was discussed again in the case law of State of MP versus Ram Sagar Yadav and Ramavati Devi versus State of Bihar. See, for every guideline, the case laws are being referred. After principle 1 and 2, now it is very clear that dying declaration has highest evidential value. If it is so, then the third guideline is very important, which says the court need to scrutinize all dying declaration very carefully and ensure that the dying declaration is not result of any tutoring, prompting or imagination. For that, the court also referred the case law of Ramchandra Reddy versus Public Prosecutor. Fourth principle is if the dying declaration is suspicious, then that cannot be considered as corroborative evidence, which again referred along with Rashid Beg versus State of Madhya Pradesh. The fifth principle is to consider a dying declaration, there should be a declaration by the person who is dead. Without any dying declaration, there cannot be any question of considering something as an evidence as dying declaration because there is absence of dying declaration. Here the same was referred along with Kate Singh versus State of Madhya Pradesh. The sixth principle is if a dying declaration suffers from infirmity, in that case such dying declaration cannot be considered as basis of conviction, which was read along with Ram Manohar versus State of Uttar Pradesh case law. What if some details are missing in dying declaration? That is what laid in seventh principle, where it was held that merely because a dying declaration does not contain the details as to the occurrence, it is not to be rejected. So it needs to be considered, and for that the case law referred was State of Maharashtra versus Krishnamurthy Lakshmipati Naidu. The eighth guideline is very important and very interesting. What if the dying declaration is too short? It was held that the short dying declarations are also very important because such statement can itself guarantee the truth. So that will also be considered, which was read along with the case law of Suraj Devo Oza versus State of Bihar. The ninth principle is related to the mental condition of the person who has made the dying declaration. Now most of the time we think that if it is told by medical practitioner, it has more value. But remember, a medical practitioner says that the person who has made the dying declaration had no mental fitness. But on the contrary, if an eyewitness says that the deceased has mental fitness, in that case, the eyewitness reference will be considered. That is what discussed under ninth principle, which is again referred with Nanuha Ram versus State of Madhya Pradesh case law. The 10th principle says where the prosecution version differs from the version as given in the dying declaration, the said declaration cannot be acted upon. Remember, the dying declarations are mostly utilized by prosecution side, and this particular guideline is discussed with State of UP versus Madan Mohan and others. I think I said 10 guidelines, but remember there are 11 guidelines. The 11th and the last guideline is related to multiple dying declarations. If a person has already made dying declaration to someone and then he makes dying declaration to another, or if a person makes dying declaration to a same person in two or more situations, and if there are any conflict between the first one and the later, then the first one which is made will be considered as the most prominent evidence. Now it will not be completely squashed away, it will given some importance that way, and for that the case law reference which are being added here is Mohanlal Gangaram Gehani versus State of Maharashtra and Mohanlal and others versus State of Haryana. That's my time on dying declaration. Now if you ask me, sir, do we need to refer one more video for the same subject? I will never say no, because every single video on this topic will give at least one new aspect related to the subject. So you can refer as many as videos on this particular subject, because this is very interesting and a very vast subject. However, somewhere we have to stop if we have started something, and I have started a session and I have to conclude. With that, I am signing off. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.